Good morning, everyone. Welcome to the Law Offices of Daniel Hunt's Advanced Estate Planning webinar. We are just waiting for everyone to get fully logged in, and then we'll go ahead and get started this morning. We do appreciate you being with us. I know that many of you have attended our Estate Planning 101 class or our client seminar in the past. We originally planned to host an in-person Estate Planning 101 seminar this week, but due to the current restrictions on in-person gatherings, we decided to switch to a webinar and share some valuable information that we've never shared in the class before. So we hope that this class will help you feel more confident about the future of your estate plan. And while we are waiting for everyone to get fully logged in, I will go ahead and introduce myself. I'm Stacy Groh. I'm the marketing director at the Law Offices of Daniel Hunt. And just to let you know, we will be recording this session today so that we can make it available in the future on our YouTube channel and also the webinar page of our website. So if you'd like to rewatch it at a later time, share it with someone you know, or if you need to leave early today, it should be available soon there for you. All right, so let's go ahead and review. Let's go ahead and get started. And Dan, if you could go to the next slide. I'm just going to give a quick Zoom overview. I know a lot of us have been using Zoom, but just in case there's some for whom it's the first time, if you are on a computer, you can move your mouse to the bottom of your screen and view your controls. Bottom left is going to be your audio if you need to adjust that at any time. Also on the bottom, you'll see options to ask a question. There's a Q&A box and also a chat box where you can communicate with us, the hosts, and we may also share some links and information with you throughout the webinar. If you have a question during the presentation about something Mr. Hunt has said or about estate planning in general, you can use the Q&A box to ask for clarification at any time. We are going to save time at the end for a live Q&A session with Mr. Hunt, and we will attempt to answer as many questions as we can get to at that time. If you have a question about your personal legal needs or those of someone you know, please contact our firm directly at our website that's listed on the bottom of each slide, and we'll be able to offer some personalized advice that way. And this is an interactive webinar, so we wanted to kick off today with a poll. So I'm going to go ahead and launch our poll right now. And there are two questions here. I'll give you guys a minute to weigh in anonymously. The first question is, how would you describe your current level of estate planning know-how, beginner, intermediate, or advanced? And then which option best describes the state of your estate plan right now? I have no estate plan in place. I have an estate plan, but it needs to be updated. Or I have an estate plan in place and it has been updated in the last 5 years and no changes are needed. So I'll give you guys about a minute to weigh in and then I'll share the results so we can kind of tailor today's presentation to our audience. And we'll just have about 20 more seconds if you want to weigh in. Okay, 5 more seconds here. And we're going to go ahead and end our poll at this time and share our results. So it looks like we have 25% 25% beginner, 75% intermediate, and then it looks like pretty much everybody has an estate plan. 39% say that it does need to be updated, and 61% say they're all up to date. So perfect. I'm going to go ahead and finish that up. Perfect. Well, that will help us to tailor our presentation a bit. Dan, if you want to go to the next slide, I can go ahead and introduce you. So our speaker today is Daniel A. Hunt, a graduate of McGeorge School of Law. Daniel A. Hunt is lead attorney and owner of the law offices of Daniel A. Hunt. He is a State Bar of California certified legal specialist in estate planning, trust, and probate law. In 2019, he was named Best of the Bar by Sacramento Business Journal in 2019, and this year he was named a Northern California Rising Star by Super Lawyers. Mr. Hunt is a member of the National Academy of Elder Law Attorneys and the Sacramento Estate Planning Council. He serves in the estate planning clinic run by the Voluntary Legal Services Program of Northern California. He also serves as court-appointed counsel for the Sacramento County Probate Court. He loves spending time with his family, golfing, skiing, hiking, and traveling. And with that, we're going to go ahead to the next slide, and I will turn the time over to Dan.
All right. Thank you, Stacy. It's good to virtually be with everybody this morning. Last time we did this, I was broadcasting from home as well. I'm still broadcasting from home. We did learn to unplug my printer and scanner so that in the middle of my webinar, my children aren't printing their homework to that. Those of you who were with us last time remember the great scanner incident of early 2020. But we've fixed that, but the two youngest of my 5 children, they're out of the house. They're the noisy ones. They're off, I think, at preschool and one of the other schools there. But the others are here. If you do hear a bit of running around, I apologize. I have asked them to keep it down a bit, but they're kids, and that's all right. And then the other thing, I've already appeared this morning in court, and thus the bow tie and the suit looking sharp, right? And the lawn folks for my neighbor have already come by with the blower during court proceedings. So hopefully that doesn't happen again on our webinar today. And from the poll, nobody put advanced. So that's great. That's why you're here, because this is the more advanced estate planning seminar. We're going to talk about things that will help you to get to that point so that your trust, because it looked like everybody really had already a trust in place. Some of you think it might need to be updated. Others of you think, no, it's good. But we're going to talk about how you can make sure that it remains good. So that's going to be what we're going to talk about today. But we first want to start off with our story of how we ended up here with this law firm. And it involves a car accident when I was 15 and a half, almost 16, how it led me on the trajectory here. I had just gotten my driver's permit, my learner's permit, and I was very excited to be driving a car. And my dad, of course, was there with me as I was driving one day. I'd picked up my friend, Sam, and we were heading off to go on a week-long camping trip up at a lake, Lake Shasta. And so I picked him up and we were driving to the meeting point where we were going to meet some other friends to head up there. And I grew up in Oak Grove. And when we were driving by Oak Grove High School, as you pass that and you're heading towards the center of Oak Grove, there's a Big O Tires right there on the left-hand side if you pass the high school. Well, high school summer school had just let out. I thought I was very cool driving a car finally. And there were some cute girls that were walking home after high school had let out for the summer school. And my window was down. I thought I would be very suave, very debonair. And I said to them, hey, ladies, calling attention to the fact that I was driving and thought I was cool. And the car in front of me had stopped and I proceeded to rear end that vehicle. Luckily, it was a very minor accident. I was probably going a few miles per hour, but rather embarrassing. They fell on the lawn right there in front of the Big O Tires in Oak Grove, laughing at what they had just witnessed, being catcalled by a 15-year-old boy who then proceeded to rear end the car in front of him. And the folks that I rear-ended, there were some older folks, and I checked to make sure they were fine. Everything seemed to be fine. There was no damage to my car, a minor dent to their bumper. A police officer came and took a statement, and I thought that would be the end of it. Well, it wasn't. We got a letter saying that we were being sued by the people that I had here rear-ended. And this was very, very shocking to me. It was very scary because we didn't have money in my family growing up. And I thought, oh my gosh, my parents are going to be sued. I'm gonna cause their failure, their bankruptcy. I can't believe this. It's very, very an experience that left me scared. Well, our insurance company, they of course have lawyers, and their lawyers, they just sent a form for me to fill out as to a statement, sent it back, and then the next thing you knew, the problem was gone. And I thought that was really, really cool, that I was there in this vulnerable situation, and that these lawyers came in riding on their white horses for this little fender bender accident and made it go away. So that was something that left an impression on me as a young boy. And I thought, that's something that I want to do. I want to be a lawyer. I want to have people or help people that are in a vulnerable position or don't know what to do, and then I can help them. So that's what has driven me to being a lawyer today. And what's driven us, quite frankly, to our firm vision, as we have there, it is consistently driven to provide valuable information for our clients' peace of mind. I love my job. I love what I do. It's honestly, it's such a lucky position to be in, that I wake up every morning and I love going to work. And that is what drives me right there, is that I am driven by providing information that gives my clients peace of mind, whether it is with estate planning, whether it's with a trust administration or probate, somebody's passed away or incapacitated, and helping them through that process, or whether it's all the way through litigation, where we have family members who may have run off with money, or contesting a trust, and they, families that can't believe that now they're in the middle of this trust contest, that their brother, their sister, or their step parent they've known for years and years and years is now trying to do them wrong, and that we can be there to provide the peace of mind. So that's our vision. That's what drives all of us at our firm every day, to do what we do and to help people understand the law, apply it to their facts, and give them peace of mind. That's what we do. So now today we're talking about how to avoid the number one estate planning mistake in our webinar today. And this is the number one thing, that when clients who've already have their estate plan set up, the number one mistake they make is that they've got assets outside of their trust, improperly titled assets, because they might have a great trust, but if you don't have assets in it, it doesn't do any good. So number one, how to avoid that is making sure that all assets are titled and transferred properly into your trust. So listen up here. For those of you who've got those trusts, which is everybody who's listening, because nobody here said they didn't have an estate plan. First of all, titling in there, real property. To title your real property is dirt and anything that's attached to it. Remember that. So if you have some bare land, that's real property. If you got a home, that's real property. So to transfer those into your trust, that's done by way of recording a trust transfer deed in the county recorder where that property is located. So most times this is done by the attorney who drafted the estate plan, or it might be by someone else, another attorney that you came to afterwards, after you did it. But typically it's either done by the attorney, or it can be done by a title company, where you've purchased the property, you've said, here's our trust, or here's our certification of trust. Please make sure that you title this property into our trust. So for example, if you had a trust created and then you purchased a property after the fact, when you're going to close title and they're saying, okay, how do you want this title to be vested? You need to make sure that it's vested with you as trustee of your trust, or you and your spouse, whoever the trustees are, as trustees of your trust. So ensure that happens. If the title company doesn't do it, because many times if it's being financed, a bank will not allow you to hold title in a trust, because they're saying, we're not lending money to this trust. We're lending money to you as an individual. So the title on the deed has to match the loan. And they say, nope, we won't put it in your trust. We're just going to leave it to you as an individual. That's where you would need to go and probably speak with an attorney and say, hey, I need you to transfer this title on this property into my trust for me. The attorney will draft up a deed, transfer it from you as an individual or as joint tenant with your spouse, whatever you chose to do when you purchased the property, and then transferring it into your trust with you guys as trustees. So that's real property, how you transfer that into your trust. Now, if you sometimes, as I'm going to skip down here to common pitfalls and solutions, when you refinance a home, many times a bank, once again, if you refinance, they say, hey, we're not lending money to this trust. So they take the property out of your trust, put it in your name, lend you the money to refinance your loan, pay off the old one, and now you've got a new loan. And then they do not put your property back into your trust. It stays in your name. This happens many, many times. And we have to deal with this because folks don't get it back into the trust. They end up passing away. And now we've got to go to court to get that property transferred back into your trust. So same analysis goes there. If they do that, you can either A, say, no, I don't want to do that, and you can go find a different bank to refinance with, or B, if you want to stick with that bank and they say, well, we're going to take it out and give it to you as an individual, then you say, all right, you need to go and speak with an attorney afterwards and make sure that you get a deed drafted to put that back into your trust after you're done with that refinance. Okay. So any questions on that, put those in the Q&A, and we'll jump to those during our Q&A session if that's unclear. All your bank accounts are pretty dang simple to get into your trust. That's taking your certification of trust. You take that down to the bank and you tell them, hey, I want to make sure that my accounts are titled into my trust. And then they will have you fill out and sign a new signature card with the title being, instead of you as an individual or you as joint with your spouse, it will be you as a trustee of your trust. And you sign that, and then it's into your trust. Same thing with stocks. Those you're going to contact, if you use a broker, you contact your broker and tell them, hey, I want to hold my stock portfolio in my trust. They'll do the same thing as the bank. You would sign a new stock ownership form there, and they transfer that into the trust. Same thing with bonds. Whoever holds that, it's usually held by your broker in your portfolio. And then investment accounts, the same. Brokers, you contact whoever is holding those assets, tell them that you've done estate planning, you've got a trust, and you want to make sure that the title to all of your assets are held in your trust, and they'll put those in. Then only if convenient or very valuable vehicles. So many times people ask me, do I need to have my car titled into my trust? And the answer is 99.9% of the time, no, you don't need to title your car into your trust unless you're driving like a Rolls Royce and it's worth hundreds of thousands of dollars. And somebody may say, no, that doesn't fall under a small state affidavit, and you need to probate that. It's very rare that happens. So most folks, it's fine. You don't have to title your vehicle into the trust. It's a matter of after you pass away, the administrator or the successor trustee of your trust will go to the DMV, fill out a form, and then transfer title that way after you've been gone for 40 days. That's the law. Other assets that cannot be titled in your trust, your retirement accounts. So retirement accounts, you cannot hold in your trust. The ownership of the account has to stay with you as an individual. Okay. So that's your IRAs, your 401ks, things like that, 403bs, anything like that. They got to stay with you as an individual because that's how they tax them. What you do is you can adjust the beneficiary designation on those retirement accounts, and you say, okay, well, this is who I want to get the money in my retirement account, and you list that as the primary beneficiary. Married folks, we almost always will recommend, because you want to leave that money to your spouse to take care of them if you're the first to pass away. So you name your spouse as the primary beneficiary. Then after that, if you say, okay, I just want it to be distributed according to my trust, that's fine. You can list the trust as the alternate beneficiary or the primary beneficiary if you're single. But just remember, if you have any charities that are named in your trust as a beneficiary, you do not want to list your trust as a beneficiary under the retirement account, because that can trigger the mandatory distribution of the entire retirement account, meaning that's all going to be taxed right then, as opposed to being able to spread out those tax payments over several years by leaving it to an individual in the retirement account. So once again, to repeat that, if you've got charities in your trust that are named as beneficiaries of your trust, you do not want to name your trust as a beneficiary of your retirement account. If your trust just says, leave it equally to my children or to a cousin or to whomever, as long as it's just an individual, not a charity, then you can go to your retirement accounts and you can name your trust as a beneficiary. And then it's essentially just kind of a see-through trust where the retirement account will look at, and the trustee will direct, I want you to set up a beneficiary IRA for this person, this person, this person, and fund it that way. And that's fine. They'd fund a beneficiary IRA and then continue stretching out those tax payments for several years. Life insurance, same. Most people do not hold the title or own their life insurance in their trust. It's a contract. It just says, when I die, give this much money to this person. And so with life insurance, you can name the beneficiary as the trust. It's going to pay to the trust, and then the trustee will look at what the trust says to do with those life insurance proceeds. You also can, once again, it's a contract, so you can say, I want to name my son, my daughter, my children equally as the beneficiaries of this contract, so that when you pass away, it goes directly to them. The trustee won't actually even be involved in making the claim on the life insurance because the trust doesn't have anything to do with it. So really a couple of options there. I tell people, here's your options, and then whatever's best for them, help them make that decision as to whether they want to name the beneficiary of a life insurance policy as their trust and have the trustee handle it, or just name it directly to beneficiaries and have those beneficiaries make a direct claim on it. Okay, so then coming back down here, common pitfalls and solutions. If you have accounts that you forgot to put into your trust, and then unfortunately you die before they get in there, some solutions to that is always having an updated schedule of assets. So if you have that Schedule A, which if you're a client of ours, all of you should have that Schedule A. How up to date it is, I do not know, but dust it off, take a look at it, and make sure that it is up to date, that it reflects the current assets that you have. Because as long as you have that, and you have an account that you forgot to put in your trust, and if it triggers a probate, then we would be able to go show a judge and say, hey, we want, it's called a 850 petition, California Probate Code 850. We'd be able to show that to a judge and say, Your Honor, the decedent forgot to put this account into their trust, but listed it right here on the Schedule A. So do not make us probate this, because they did not intend for it to go to probate. They intended it to be held by their trust. And so give us an order that we can go and grab that asset and dump it into the trust and avoid probate. So that's the number one solution, is to have an updated schedule of assets. Then we can avoid the full-blown probate. And remember, these are assets that are going to be above the $166,000. If you're below that, the aggregate value of all of your assets, we won't have to go to a probate. We wouldn't even have to do an 850 petition. We do what's called a small estate affidavit, where once again, we have to wait that 40 days after you've passed away. Then the person who's legally entitled to claim the assets, which is your successor trustee typically, will be able to sign that small estate affidavit saying, hey, bank, this estate is not being probated. The aggregate value of all the assets is less than $166,000. It's been 40 days from the date of their death, and I am legally entitled to it, so turn it over to me. And if they don't, and we have to go to court, then that bank who refused to honor that small estate affidavit, they have to pay the legal fees to do that. That's how the law works. So that's a solution to that problem. And then also, even on top of that, is making sure that your trust is up to date with all of the provisions, because we've had a law change just recently within the past 2 years that allows us to put essentially a general assignment and transfer clause into a trust that says, I can hold, as a trustee, I can hold things in the name of my trust, or I can just hold as an individual, but it's still a trust asset. Therefore, we wouldn't have to go through a probate, because even if you're sitting there holding that bank account and it's just your name on it, you're saying your trust, well, that doesn't mean that it's not a trust asset. It still is a trust asset. It's listed on that Schedule A. If there was intent there showing that this is a trust asset, then we don't have to pull it through probate. So making sure that your trust has that provision is a good idea. And once again, that came out a couple of years ago. Okay, so any questions on that number one mistake, is that you've got a trust, but then you've mistitled assets or forgotten to put assets into your trust. Put it in the Q&A box if you have any other questions on that. But as long as you go through all your assets that you own and you make sure that they're properly titled, including your real property, your bank accounts, your brokerage accounts, all your investments, everything like that, then you're going to be avoiding that number one mistake of having assets that are mistitled or out of your trust. Okay.
Next. Dan, just to interject, we do have at least one person who has an estate plan, but it is will-based. So there may be others who don't have a trust, but they all have estate plans. So.
Okay, so we got one of you out there who doesn't have a trust. So I would suggest that you obviously, if you're above that $166,000 threshold or the $66,000 in non-real property, that's going to push you into probate. Most people want to avoid probate, and so that's where they turn to a trust to help them avoid that court procedure that on average in California is about 2 years and costs on average about 4 to 5 times what it does to administer a trust. Okay, thank you, Stacy. All right, next we're going to talk about letters of instruction, because this is something that we don't, as the attorneys, the drafting attorneys, we don't do this. This is something that our clients do because they're the ones who have to do it. And by virtue of that, where it's like, okay, clients, you handle this. Many times they just don't do it because they expect that the attorney will take care of everything. But this is something that the client's got to do. So what is a letter of instruction? That you can see there, it's an informal supplement to an estate plan, which provides your successor with detailed information concerning your wishes after you die. These are the things that you don't pay the lawyer to do, because the lawyer is expensive and you don't want to, divide all of the artwork or the knickknacks or the watches by son or daughter, or the jewelry by son or daughter, like that. That's something that you'd put in the letter of instruction. 3 things to know about it. First off, it's not as legally binding as other estate planning documents. If it comes down to a discrepancy between your trust and a letter of instruction, the formalities of a trust will typically win the day if there is some sort of discrepancy between those 2 documents. But it does have some legally binding effect, because you can say, okay, if this is drafted and signed and it says that this pen, I wanted to go to my son Connor, then that's legally binding. Like, my other son Mitchell wouldn't be able to show up and say, no, I want the pen. If it were to go to a court and then you hold that letter up and say, yes, this is the decedent's handwriting, they signed it, pen says it goes to Connor, then the judge is going to rule in that favor. So in that sense, it does have some legally binding effect. But if the trust says, I want the pen to go to Mitchell, and the letter of instruction says, I want the pen to go to Connor, the formalities of that trust may win the day, especially if the trust is signed after that letter of instruction. So it's can be complicated, but hopefully not. We're going to try and make this very simple. We just have to, of course, have 17 disclaimers about everything we say, because we're lawyers and that's what we do, right? There is no required structure or format. Like, you don't see in the probate code, this is what you have to follow in order to make a letter of instruction. It's not there. It's very informal, okay? It should be updated annually and kept in a safe place where it's accessible to your successor trustee or executor. You can also send a copy to your estate planning attorney to place it in your file. So I always tell my clients, you can draft that letter of instruction up, instructing your successor trustee how to handle these things. In the next slide, we're going to go over all the things that they can do with it. And then put a copy with your estate planning documents. And then also, we say, if you'd like, send a copy to us and we'll keep that with your documents so that we can, and when you pass away, and say, hey, did you know about this letter of instruction, to the successor trustee, and make sure that they carry out those instructions. But I do warn them, if you destroy it, if you rip up yours and you have sent a copy to us, please make sure that you tell us so that we can destroy that one and put it in the shredder as well. If it's changed, or if you no longer want the successor trustee to carry that out. So just make sure that if you destroy one copy, you destroy them all, so there's no confusion. Okay. Now, what can we do with the letter of instruction? A lot of information on this slide, so we're going to go ahead and read through some of this and discuss them. First of all, specific bequests for personal property, such as who you'd like to have, family heirlooms, jewelry, firearms, etc. This is the main purpose of this letter of instruction. Like I said, the pen. I'm a pen guy. I love pens. So it may be that I don't want to, list out in my trust which pen, which of my kids get. I would probably just write that out in a letter of instruction, because I have a great pen. Oh, where is it? Right here. Oh, I hit it. But it's a Beatles pen, and so I went to a Beatles show with my daughter in Las Vegas. If any of you've been there in Vegas, go to the Cirque du Soleil love show, Beatles. It was amazing. And I got to share that experience with my daughter and my wife. and I got a pen for the Beatles on that trip, and that's something that I'd write down in that letter of instruction. And I've told my daughter, but I'm going to write that down in the letter of instruction so that she knows, hey, Mackenzie, that pen is yours, and she'll always be able to remember that for me and all that kind of good stuff. That experience that we had. So those things, the jewelry, the firearms, the heirlooms, all that list, you don't want to pay a lawyer to make that laundry list of dividing things, the stuff at your house. That's what you put in the letter of instruction. So identify it sufficiently, try and, think like a lawyer and say, okay, do I have two things that kind of match this description? You can even attach pictures if it makes it easier to say, this goes to this child, this goes to that friend, do it that way. So also in your letter of instruction, personal desires concerning your burial and funeral, etc. This is the what song you want to be sung at the funeral, or I don't want a funeral at all. Cremate me and spread me here, there, and be done with it. Whatever you want, that letter of instruction is where you want to put that. Personal sentiments, messages to your loved ones, and expressions of love to be read when you are gone. Obviously, very, very powerful if you put that in there and that's read after you're gone. So those messages, how much you love, what those people meant to you, that's for a letter of instruction. It's not for a trust or a will to be read and interpreted in open court or anything like that. Not there. A letter of instruction is more appropriate for it. Instructions for the care of any pets. So you got any pets and you want to make sure that they are taken care of to your standard, then that's where you'd put that in the letter of instruction. Information to manage your digital life, like passwords, social media accounts. This is where you'd put that in the letter of instruction, because many times if you're transferring assets and you say, okay, the bank's like, hey, we want a copy of your trust, and you go show them a copy of your trust and you have in there all the passwords to all of your entire digital life, your bank passwords. Well, the bank might already have that, but your email passwords, whatever it is, you don't want that in your trust documents. You'd want that just in a letter of instruction saying, okay, successor trustee, here's how to get access to my online accounts. Details about the whereabouts and contents of a safe deposit box. Also, you can put that in the letter of instruction saying, hey, I got a safe deposit box, trustee at the Bank of America on Fulton. Then location of legal and financial papers like your estate plan, birth and marriage certificates, tax returns, divorce, citizenship papers, military records. You can put that in there. Contact information on any debtors, mortgages, credit cards, things like that should be paid. Put that in there. And then names and contact information for the professionals who are going to help your successor trustee, like attorneys, CPAs, bankers, and brokers. You can put all of that in there. Okay. So any questions on letters of instruction? Put those in the Q&A box. We'll get to those. And then encourage you to draft those because it will help your successor trustee. And in the informal administration, it will help them greatly, much more so than having your lawyer try and draft those things up, because we won't do as good a job. And it might take a couple hours to draft, and you don't want to pay a lawyer to do that, a couple hours of their time. All right, next one, how to prepare your successor trustee. So we encourage folks that are our clients that they come to also maybe have their successor trustee come and take a listen as well. But this is how you can prepare your successor trustee to be successful. And this is a really big deal to me because how much litigation I do in trust and estates, much of it is because the successor trustee was just not prepared for their job. They weren't instructed properly on what they should do. They're out there just kind of acting rogue and making a mess of it. And now that's when the beneficiaries go off and say, this successor trustee has no idea what they're doing, or they're doing it terribly, and we're going to go hire a lawyer. And now we're going to sue to have that successor trustee removed. The successor trustee objects, saying that they're doing a great job. And now we just have this big fight in court and lots of money being spent because the successor trustee wasn't prepared properly, or you just plain picked a bad one. So we'll try and avoid that, obviously, when creating our estate plans. First thing that can be helpful is creating that letter of instruction so that you can avoid, because the successor trustee will be in charge of dividing those personal property items. So it really can be that the biggest fight comes when we're dividing personal property. I've been on cases where siblings have been at each other's throat over items of personal property. literally incurring thousands of dollars in attorney's fees fighting over things like lace doilies. If you put the lace doilies in the letter of instruction and say, Kate gets the lace doilies, then end of discussion. It's over. The child will see that's what mom or dad wanted. And so I'm not going to contest that, because so many times people get so wrapped up, the successor trustees or children get so wrapped up in saying, I just want to do what mom or dad wanted. That's my war, is that I'm willing to go to war to see that mom and dad's intent is carried out. So that if you make it clear in that letter of instruction as to who's going to get what with the personal property, then that can really help your successor trustee in dividing all of this stuff. Because as you can probably imagine, sitting in your home, look around and say, okay, who's going to get all this stuff when I pass away? Everything in my room alone, my desk, my computer, my bike, once again, my pens. A successor trustee has to make all those decisions as to who's going to get what and make sure that everybody's going to be happy. If they just say, well, beneficiaries free for all, go in there and have at it, that's where you're going to end up with fights. So letter of instruction will be very helpful. Be clear about your wishes and communicate them often. So I would encourage you that you be clear as to what's going on, what their job will be, but also make sure that you don't give them bad instructions, because that's the trouble, is that if you don't understand what your plan is, and then you're trying to explain that to your successor trustee, now they have an incorrect idea and it conflicts with what is in the document, that can lead to a terrible, terrible outcome. But as long as you understand what your plan is and you tell them, okay, successor trustee, you're going to be in charge of this plan, and this is how I want it to be dealt with, and it also is in conformity with what the plan says, then that's a good thing. They're going to be able to understand that and carry it out. Tell your successor trustee where your estate planning documents are located so they can be accessed when needed. Obviously, they got to know where the latest plan is, the controlling document. They got to know where that's at. So typically our clients, they have some original documents, like your powers of attorney, your advance directives, things like that. The other original documents, like your will, your trust, those originals are actually kept in an offsite storage facility, safe from flood, earthquake, fire, everything like that. So you can tell them, okay, here's original documents, my power of attorney, advance directive. You need to use that if I'm incapacitated. But when I die, the original documents are held by the attorney, by the firm, and you can go access them with them. So then obviously number 4 here, if you're a client of our firm, be sure to give them our firm's contact information, inform them that as a successor trustee, they're entitled to a no-cost consultation when you pass. This is something that we have done for as long as I've been around, that when somebody passes away, we offer a no-cost consultation with the successor trustee and go through all of the steps of the trust administration with them. There are items that obviously the successor trustee has to take care of. There are items that an attorney should help them with. Drafting a notice under probate code section 16061.7 is very specific how it has to be done. There's specific language that has to be used. There's specific font size that has to be used in order for this notice to be legally binding on the beneficiaries. That's something that you should have a lawyer's help with. Transferring title on real property, things like that, where it's like a lawyer should help with that to make sure that it goes smoothly and is done correctly, so that you don't have a fight later on down the road because property wasn't transferred correctly. So we go through that whole checklist and tell them what their job is as a successor trustee and how to do it. So tell them to do that. And then if they do that, they're golden, because then they're going to have an attorney that can tell them how to do their job exactly. So that's probably the most important one there, to prepare them, saying, go talk to the lawyers after I'm dead and gone, because they'll tell you how to do the job properly so that people don't end up in a big old fight. And then also you can suggest they visit our website page called For Successor Trustees and download our guide or checklist for successor trustees. It's really, we have a great website where there's a lot of content there, and they can go and visit our website and learn a ton about their job. just by visiting that and going through that checklist and guide. All right. So any questions on how successor trustees, how to prepare and what to do? Once again, put that in the box there and we will get to those when we're taking questions. Next up, how to protect against litigation. So this is another pitfall when you say, okay, I've got a trust, so I'm beyond the basics of estate planning. I've at least advanced to intermediate, so I've done some planning. But now, how are we going to avoid having litigation creep in on your estate? Number one here that we're talking about avoiding do-it-yourself estate planning. Online documents, I warn people that doing their estate planning online, the trouble with that is that you are your own lawyer at that point. In California, there's two people that can do your estate plan for you. One is yourself and the other one is a lawyer. And in California, there's also two people that can perform a surgery on you. One is yourself and two is a licensed physician. So if you're going to, say, I want to cut the tumor out of my own arm. You can go ahead and try and do that, or you can hire a doctor or surgeon to do that. But you can't go ask your neighbor to go and cut that out unless they are a physician. The same thing when it goes to doing your online estate plan. You are essentially doing your own surgery there. So you're going to be the one to figure out what is the best estate plan for you, how things should be distributed. Then also titling assets properly into your trust. That's all on you, because if you're doing it online, then those online providers of documents, they say, hey, we don't represent you. We're just providing the forms. You're doing it yourself, which is completely legal, but might not be the best idea. Also, writing your own amendments. This is very, very troublesome because many times our clients where it's like, okay, we did our estate plan, the big trust, that big whole packet of papers. Obviously, we would never try and do that ourselves, but I just want to write a little simple amendment and add in some beneficiaries or add in a new successor trustee. So I'm just gonna do that myself. I mean, it was just yesterday that I was having a chat with a client about their desire to have a friend add some charities into her estate plan. And the trouble is that already this friend had letters issued by a doctor saying that they were incapacitated, that they didn't have the mental capacity to manage their own financial affairs. And now we're going to have, after that letter has been issued by a doctor, an amendment done at home saying we want to add these charities in to my distribution. So you can see the problem there, that if this person was incapacitated in March of 2020, and now here we are in October of 2020, and there's a change to who gets what in the estate plan, you can see that's problematic. This is something a lawyer would obviously say, okay, how can we do this? And I offered solutions, but they weren't great because many of the solutions involved getting two lawyers involved, the drafting attorney and then a certifying attorney to certify that what the drafting attorney had done was not the product of undue influence or lack of capacity or fraud or a mistake. And then on top of that, getting a capacity declaration, new one from a doctor, showing that that individual had testamentary capacity at least, because there's different levels of capacity. You have testamentary capacity, you have contractual capacity. Testamentary capacity is much lower, where it's essentially you understand what you own and who's going to get it when you die. Contractual capacity is a higher standard, where it says if you were able to, for example, read a contract and understand what's going to happen as a result of that contract, that's contractual capacity. It's a higher one. So when doing your own amendments, there's no analysis of that happening by an attorney who would then be able to show up in court when you've passed away and say, yes, I met with the decedent. Yes, I discussed what her assets were. She understood them. Yes, I discussed how they were going to be distributed when she passes away, and she understood that. So that lends obviously weight to the case of this is how the decedent wanted their estate plan divided, as opposed to a handwritten note at home with nobody there to be able to testify as to whether that whether that decedent, obviously who's now passed away, whether they had capacity to understand that, whether it was the product of undue influence, somebody was sitting there over their shoulder coaching them, leave all the money to me, mom or grandma or whomever, or whether they actually understood that if it's a mistake that was made in there, those things. With doing your own amendments, you're all on your own when figuring that out. So that's why I totally, utterly discourage doing your own amendments, because I've dealt with the fallout so many times on these homemade amendments that create just an incredible mess for us to clean up. Because if it's vague or ambiguous, we got to figure out what do they mean, and we have to pull in all the facts, all the discovery, and it costs thousands and thousands of dollars to do that. So avoid doing your own amendments. And also, once again, if your clients of our firm and you've had your documents recently updated, you'll see in there's instructions, or not only instructions, but a mandate in your trust document as to how an amendment has to be drafted. And it has to be approved as to form by an attorney. So that means that if you've had a document or a trust that's recently been put together by our firm, it's going to say a homemade amendment, it has to be approved as to form by an attorney in order for it to be valid. If it's not approved as to form by an attorney, then it's not a valid amendment, and it should not be enforced as part of this estate plan. So that's how serious we are about making sure that documents are done properly, because we've just seen it so many times where they're not. Okay, number 2, to avoid litigation, avoid choosing an inexperienced attorney to create or update your estate plan. I have so many stories I can share. Maybe just one right now is to having inexperienced or sloppy attorneys doing these estate plans, and how they can result in really, really bad situations where we end up in litigation and families being torn apart. One that I'm involved in right now was this married couple, and they had 3 children. And as their estate plan was set up, that they wanted to leave particular parcels of property to their children. But in the end, after the properties were divided, they wanted everything to be equalized, so that if one child got a property that was worth $200,000 and another child got a property that was worth $300,000, that with the rest of the assets that were there, that you equalize the distribution, so that each child would both end up with, if the total amount to be distributed was going to be $400,000, each child would end up with $400,000. That means the child that got the $300,000 property would get $100,000 in cash, and the child who got the $200,000 property would get $200,000 in cash, so that it's equalized. Each child ends up with $400,000. That's the original plan. Well, husband dies, wife then goes to have the trust looked at, attorney then updates this trust and takes out this equalization clause, because she just threw in her boilerplate distribution there after making those individual dispositions of the properties to each child. Put her boilerplate as then everything else is divided equally, but didn't have an equalization clause, because that was not a normal thing in this attorney's drafting box of just pushing buttons saying, okay, draft that. And obviously through our discovery, we found the attorney never even discussed this with the decedent. It wasn't brought up as to something that she wanted to change. So now you have obviously the children who are fighting because two children think that the equalization clause wasn't supposed to be taken out. The other one, who obviously walking away with more money, says, oh yeah, that was mom's intent, because you had an attorney who did sloppy drafting. That's obviously a sign of being inexperienced, because you have to be very meticulous with these distribution clauses. So avoid doing that. I've seen many, many times where just you've got attorneys who also, they might do the planning, but then when they never do administration, they don't know the result of what their plan is actually going to look like when their client passes away, can lead to problems as well. So Number 3, be very, very careful when selecting a successor trustee. My goodness, be really careful. There are times where I'm working on cases and I just think that this successor trustee, the decedent had no business naming this person as a trustee. And that's also the benefit that you get of having an experienced attorney help you with your plan, is that everyone just thinks, oh, it's got to be the oldest child, or it's got to be one of my children. Well, if all of your children are fighting, or they just don't get along, it's not a great idea to be naming one of them to be in control of your the distribution of your trust, because then they're just going to be at each other's throats. I mean, when you're dead and gone, that glue that holds them together, and now it's just money is being distributed there, family relationships can fray very quickly. I'm more than happy to tell clients where it's like they're worried about naming a child or anything like that. You name a professional fiduciary. They are not expensive. Quite frankly, many times the professional fiduciary fee is lower than a fee that a family member may take of 1 or 2%, because these professional fiduciaries will just charge hourly many times. So it ends up being less. And the professional fiduciary, they don't have a skin in the game. They're just there to do their job, say, okay, collect the assets, pay the debts, look at that letter of instruction, divide personal property as it's listed there, but then to just do their job. They don't got skin in the game. They just want to do it and not get sued for what they're doing as the trustee, because the beneficiaries are obviously the ones who can end up suing them if they do something incorrectly. But be very, very careful when selecting those successor trustees. Successor trustees who have this mindset of they know everything. I've got the probate code right here. I think I've shown this to most everybody. Here's your California probate code. A successor trustee, a layperson who thinks, yeah, I know the code, I can deal with this. It's just they're fooling themselves. So you don't want to have somebody who thinks, I'll do this on my own, you'll figure this out, because that just leads to problems. All right. And then also number 4, avoiding do-it-yourself trust administration. That's what I've been talking about, is successor trustees who just say, I'm going to do this on my own. They don't send out notices. They don't end up accounting. And when they eventually get to a point where they say, well, gee, I don't know what to do at this time, what do? They take their hands and they sit on them. And so months and months and months, if not years, go by, nothing happens. And now, until finally a beneficiary gets upset enough, and that's when they go hire a lawyer. And now beneficiary has lawyer sends demand letter to successor trustee gets demand letter. They say, oh crap, I'm getting sued. That's when they go get a lawyer. And now you got these lawyers involved and thousands of dollars being expended to figure this out, when it all could have been avoided had a successor trustee just been smart and said, I'm going to handle this properly. I'm going to go get a lawyer who's going to tell me exactly what to do, and I'm going to carry that out. I just had, it's representing a client right now where his aunt, his father passed away like 15 years ago. Aunt was named as successor trustee. She's been administering this trust for, well over a decade. And not once had my client gotten a distribution from his aunt. And this trust held multiple rental properties for now 15 years. And until finally he'd been fed up with it, it called for an outright distribution at 25. He's now 28 years old, waited years. And now we got the trustee removed, but now also, where's all the rental money? There's 15 years of rental money that's gone. So we have to go chase after this trustee, try and get that back. But that's because I can promise you, as she was not being represented by an attorney. She's just out there doing it on her own. And it ended with a big mess and lots of attorney's fees, and having to chase this lady down in court to get a judgment against her. Not fun. So avoiding litigation, once again, as you can see there, avoid doing it yourself documents, avoid doing it yourself trust administration. Be very, very careful when selecting your successor trustee. That's a big, big deal. Counsel with a good attorney on who's going to be good. And then also select a good attorney. Make sure your attorney and your successor trustees know what the heck they're doing. All right. So now we're going to talk about trust decanting. Okay. So this is something that is very advanced, and it can be very, very helpful to our clients, especially those who have allocated AB trust. We are talking to you. If you had an AB trust, your spouse passed away, and you allocated into a B trust and some assets in an A trust, this is for you. So the decanting, it helps that surviving spouse access those B trust assets to minimize capital gains tax exposures. So this is why we would do it, because when you allocate a trust at the death of your spouse and you dump those assets into the B trust, why they would do that is to avoid federal estate taxes. Because if you have all these assets that a married couple holds, and then one spouse passes away and that spouse doesn't allocate, then the surviving spouse still holds all the assets. And when the surviving spouse passes away, all of those will be taxed by the federal estate tax if they haven't allocated. Attorneys would advise their clients to allocate, because when one spouse passes away, you'd be able to split those assets, so that when the surviving spouse passes away, the only assets that are taxed for the federal estate tax are the ones that were in the A trust, because the federal estate tax was already levied on the assets that were in the B trust. So that's why it was very, very popular to allocate these trusts when we had a much, much lower federal estate tax, $1 million. I mean, in the time that I've been practicing, I can remember a few years before I was practicing, it was down to $650,000. Now we're up over $11 million. So totally different laws going on right now. So that means that if you have less than $11 million when you pass away, you don't have to worry about federal estate taxes. So there wouldn't be any reason to allocate these assets. But the problem is, what if you've already done it? It's already done. You had a spouse that's passed away and you're sitting there with assets in an A trust and a B trust. The problem is this: and the assets that are in your B trust, the decedent's trust, their basis is whatever the value of the asset was when your spouse passed away. So if your spouse passed away 5, 6, 7, 8 years ago, then you're sitting there, especially like you think about spouses who passed away around 2008, 9, 10, 11, 12, where the stock market was so much lower, real estate prices so much lower, and you have this super low basis. Well, now 2020, fast forward, we have much higher real estate, we have a much higher stock market, and you have these assets that have appreciated greatly. The problem is your basis hasn't changed. So when you pass away, if those assets are still held in your B trust, then your children, or whoever the beneficiaries of that B trust are, they have a basis from 2008, 9, 10, 11, somewhere around there. They have an actual value way, way higher. They're going to be paying capital gains tax on the difference between the basis and the market value. So that's why clients who come in and they have these allocated AB trusts, and I do this analysis with them saying, okay, what was the basis? So how much were these assets worth when your spouse passed away? And they have gains of hundreds of thousands of dollars. You're looking at thousands and thousands and thousands that's going to be paid in capital gains tax if you don't decant it. Okay, if you don't take that old wine and put it into a new bottle. That's for those of you wine drinkers, you know all about decanting. Those of you who don't drink wine, it's decanting is the process of taking old wine and putting it in a new bottle. It adds flavor, puts oxygen in there, all sorts of great things. I don't drink wine personally, but I have friends who do, and that's why I'm told about this. So it makes it going to enhance the flavor. And what trust decanting does, it makes it so that we can enhance your assets and make it so that we don't pay taxes unnecessarily, or your estate pay taxes unnecessarily when you pass away. So didn't get to that. Limits on changes to trust terms prevent you from increasing trustee compensation. So you can't, for example, if you're the trustee, you say, hey, I'm going to decant this trust so that I can take more compensation. You can't do that. You also can't, as a trustee, you can't decant it and then say, okay, I'm going to also take away all my liability so that I don't have to worry about getting sued. You can't do that. And then also granting another person power to remove or replace a trustee. It's something you can't do either. So there's certain things when you're essentially taking trust and you're making a new one, there's certain powers and things you can't do. And there's those right there. Now, basic steps, okay? Basic steps of decanting a trust, all right? How much time do we have? Oh boy, we've got to get to our Q&A. So first of all, you draft a new trust in compliance with the requirements as outlined in that California State Assembly bill there, the Uniform Trust Decanting Act. So you draft a new trust, okay? You draft it. Don't sign it yet, you draft it. Then prepare and send out notices of proposed action to trust beneficiaries with copies of the old trust and the new trust. So a notice of proposed action is literally, it's a notice that you send out to the beneficiaries of the old trust, the B trust. And you say, hey, beneficiaries, I propose we take this action. We're going to change the trust terms from this, the old trust, to this, the new trust. And then you receive all their consents, or you wait for the objection time period to expire, which uses about 45 days. So you give them at least 45 days to object, or they can sign that consent and send it right in. And then once you've gotten those consents or the objection time period is passed, that's when you sign the new trust. And then once you have the new trust signed, that's when you go and you retitle, you take the assets out of that old B trust and dump them into the new trust. You have just taken old assets and dumped it into a new trust. You have decanted your trust assets, okay? So, and now, because you've done that, the basis will be stepped up to the surviving spouse. When they pass away, they get a completely stepped up basis. So now they're just treated, all the assets are treated as if they were A trust assets, so that the beneficiaries, when they sell those assets, they're not going to be paying capital gains tax. Literally, if they sell it within 6 months of the decedent's passing, you just wiped away all the capital gains tax by decanting that trust. So potentially hundreds of thousands of dollars in capital gains tax savings if you've got some assets that have been highly appreciated. So if you fall into that category where you've got an allocated AB trust, you really should come and speak with us about decanting, because it literally will just increase the amount of money that is able to go to your beneficiaries, because we're just wiping away taxes. Simple as that. Okay. All right. Now I believe Stacy is going to come back on and chat with us about what the next steps are for those of you who are here.
Yeah, so real quick, I wanted to mention that we did send out, I emailed a copy of these slides along with our Estate Planning Essentials ebook yesterday to all of the people who were signed up. So if you didn't get that, please let me know. I can resend it, but hopefully it's there in your inbox waiting for you. And I did want to touch on your next steps. If there is something you learned today that made you think, oh, I need to get in there and have my trust reviewed or update my estate plan, we are offering a no-cost consultation to new clients. We have in-person, telephonic, and virtual appointments available if you're interested in updating your estate plan. For current clients of our law firm, we do always offer a reduced rate on the attorney's hourly rate for our clients to have a trust review appointment. So in addition to that, also for the next 7 days, you'll receive a 10% discount on the cost of amending or updating your estate plan as well. And I wanted to say that business right now at our firm is very brisk, which is wonderful for us, but it has been a challenge for our clients who may want to get in a timely manner to meet with their attorney. We are currently scheduling appointments a month out or even more. And so what we did was we blocked off 10 time slots for you, those of you who have attended today, as a gesture of gratitude for coming within the next 2 weeks to meet with an attorney. So if you are interested in doing that, these will fill up quickly and they will fill up. So please give us a call as soon as you have a time in mind. Please give us a call or email us. I did share the link for that in the chat box as soon as you can, and let our support staff know that you did come to this webinar today, so that they can make sure to make a note of your discount and get you in sooner than over a month. So thank you so much for coming today. At this time, we are going to begin our Q&A session. Dan, if you want to go to the next slide, if you do have any other questions about what you've heard, go ahead and type them into the Q&A box at the bottom. And we do have a couple of great questions in there already. And then I'll turn the time back over to you, Dan, to answer those. Or I can read them out loud. Do you need me to read them out loud? Oh, now you're muted.
There we go. No, you do.
Perfect. So would you like me to read those out loud?
Okay, in the Q&A that we're looking at?
Yes.
Okay, I can do that. How to choose a successor trustee when the people you trust are all getting older and may not survive you. So great question. That's where I would suggest if the people that you trust are all getting older and they probably aren't going to survive you, what you can do is you can list them. You can put them in there. And if they do survive you, wonderful. Then they can act as the successor trustee. Great. But if they don't, I would suggest that you probably have like a fail-safe where it's like, okay, one of these professional fiduciaries, name them kind of last in line. And I would do it that way so that if you are the people that you trust and that you really want to be the successor trustee, name them. It doesn't hurt for them to be put down there. And then as a fail-safe, kind of the last backup, last ditch is that if they're dead and gone, or quite frankly, they're just too old to even want to act. Because that's what happens when you name people who are in their late 70s, 80s, and they come in to meet with me. And I'm like, okay, here's all the duties you have as a successor trustee. Virtually all of them are like, thanks, no thanks, I'm going to go back home. I don't want to do this. And they will decline their appointment as successor trustee. So then you go to the next in the line. So you can line those up in order of preference, but then as an alternate, as a last ditch ever, just name the successor trustee to be a professional fiduciary, and they'll do it. Okay, so that answers that. Then what is the difference between investment accounts and retirement accounts? Okay, so I'll say it this way. All retirement accounts are investment accounts, but not all investment accounts are retirement accounts. So hopefully that makes sense. An investment account can be a brokerage account where you're going to invest in stocks, bonds, CDs, whatever, that you hold that in that investment account. But a retirement account is specifically, it's governed by different laws where you get tax advantages to those. And so that's where the most common ones, 401ks and IRAs. And so with those are retirement accounts. And those are a contract that says, okay, I'm going to put money into this retirement account. And then when I die, I want you to leave the money to this person. They have beneficiary designations on those retirement accounts. So they're treated differently because your retirement accounts, obviously you can put money in there and not get taxed on it. Whereas if it's not a retirement account and you're investing in it, when you get, when it spits out dividends or income, things like that, you get taxed on it that year. With your retirement accounts, it's different, obviously. It may spit out income, but if you're not taking that income, then it doesn't get taxed. It only is taken or taxed when you take it out. So hopefully that answers that. And as a reminder, your investment account, if it's non-retirement, should be titled in your trust. Your retirement accounts, the title, the ownership cannot be held in your trust. It's got to be in your name. That has to be, that you can't change that. And then you just have beneficiary designations as to who you want to get the money when you pass away. So hope that answered that. Great question. All right, next one. If jewelry, tools, etc. are given to children before parents passing, how do we prove this to avoid sibling warfare after parents passing? That's good. We do have a trust, including 2 special needs trusts, to be created with original trust assets as part of an original trust distribution to parents and children. Okay, so great question. And that's the thing is that how do you prove it? Give it to them. And make them take it out of the house. That's one way, is that you say, okay, here, I'm giving this to you now. And this is a gift and it's yours. I no longer own it. It's completely yours. Here's my antique shotgun. Here's my golf club set. And they literally take it to their house and it is gone. So there's that, where you've completed the gift. You take it, you transfer it to them, done, completed gift. If you want more evidence beyond that, you can have a letter that's signed and notarized, a gift letter that says, I, Christopher, have gifted my antique shotgun to my daughter, Chelsea, as of this date, signed, dated, and you can even have a notary if they think that it's going to be, contested as a forgery, because notaries they testify to the person's identity that it was them. And if you want to go beyond that and you say, oh, well, I think that they lacked capacity to do this, you can attach a doctor's letter that said you had capacity on that date to do it that way. So it just depends on how secure you want to get, but to avoid the fighting, completing a gift is one thing where it's, you give it to them, they take it, it's done and over, it's completed gift. And then evidencing that by a gift letter, you can have that done as well. And so that should be pretty dang clear that you made a gift to a child, it's done, it's not part of your estate. Because once that's gifted, once again, to be clear, it has nothing to do with your trust. It has nothing to do with your will. It literally is a completed gift. It's done, it's over. Nobody has any claim on it at that point because it's done. Okay, hopefully that was a clear answer once again there. Great question. I am a trustee for a friend's trust. What liability protection do I need as a trustee? Can the trust provide that for the trustee? So it's not very often that you're going to have like insurance policies, like a profession, like for example, malpractice insurance that an attorney would carry. There are policies out there. Generally, those are seen as being a little excessive. If you just do your job correctly, then the likelihood of you having exposure as a trustee is so slim. It offsets any money that would be spent on a policy, like a professional policy, or errors and omission, things like that. Like people will get that they serve on boards of charities and corporations, they'll get errors and omission policies for them. Very rarely used in the world of trust. What is the more proper thing to do to protect you from any liability that could come on you is that you hire a really good lawyer to represent you. If you have a really good lawyer representing you, they are not going to let you make a mistake that will get you that will let you get sued. But yes, and obviously the trust pays for that lawyer so that they can represent you properly. But that's the best way to avoid liability as a trustee, is to have a really good lawyer on your team that's going to say this is exactly what you do it, so that even if a beneficiary does come and contest something that you did, object to something that you did, you have defense there that will go and show up to court and say, this is why we did it, because we're following the probate code. And I have never had a trustee that's been sued and that was liable when they're following our directions. I make no guarantees. We can't do that because of the state bar. But as long as trustees have followed our directions, not a single one of them have had to pay out a penny in any liability when they're following our instructions. So there's the answer to that. All right, a couple more. I sent a copy of our trust to our CalPERS, and I was wondering if I should have. Our trust is divided between our two children with the catastrophe clause that everyone dies at the same time when our estate would be given to charity. Will this create a problem with our retirement accounts? No, it won't, because once again, your retirement accounts are a contract. They just pay out directly to whoever the beneficiaries are on the retirement account. They may have asked for it to see who the successor trustee was, because if you name the trust as the beneficiary of a retirement account, they're going to want to know who's the trustee, who we're supposed to be listening to take directions on how to divide these retirement accounts at CalPERS. So no, it shouldn't be a problem. So don't stress over that, because it's not going to change unless you change the beneficiary form on your CalPERS account. It's not going to change who the money goes to. All right. Okay, and then I think this is our last one. Okay, so with the A/B trust, if one spouse passes away, then you have an A and a B trust. Based on what you explained, Daniel, does it mean the B trust is taxable based on when the first spouse passed away, even if the current value is still below the $11 million limit when the surviving spouse passes? So the B trust, how it works is that the A trust, that the federal estate tax is levied when the surviving spouse passes away. Whatever's in the B trust, that federal estate tax has already been levied. So you could have put $1 million into that B trust, and then surviving spouse goes on living, and surviving spouse was a really good investor, and that B trust is now at $1 billion. When surviving spouse passes away, there is no federal estate tax on that B trust. What you're going to have a problem with is an enormous capital gain tax that went from 1 million to 1 billion. But tax rates, it's obviously better to pay the capital gains tax if you have to, as opposed to a federal estate tax. So that's why the A trust and B trust analysis are totally different, because A trust, you have to be worrying about the federal estate tax. You don't have to worry about the capital gains tax, because that, once again, stepped up basis, and now no capital gains tax on the A trust. B trust, you have to worry about capital gains tax and not the federal estate tax. So they're completely flip-flopped about which tax you're worrying about. So hopefully that makes sense. Great question. But yeah, doing the analysis there is B trust, you worry about capital gains tax. A trust, you worry about federal estate tax.
And then Dan, there's one more question from the chat box, which is Proposition 22. He wants to know if Proposition 22 passes, if it will have an effect on the way trusts are written. Not sure if you are familiar with that or not.
Gosh, dang, was Prop 22? I thought Prop 22 was the sentencing reform. That's what I thought it was. Where's
Too many propositions going on right now.
When I need it. That is a good question. Email me on that. I thought, yeah, because I thought the Prop 22 was the sentencing reform, as to their ability to give out harsher sentences on criminals. Obviously I'm wrong, because I don't know why that would affect the way that. So, but
okay.
Maybe I'd follow up with whoever that was. Shoot me an email, because I'll get you the answer. And then somebody just in the chat box, are there still death and estate taxes with trust? Yes, there. The way that was death. There's death no matter what you do. I'm sorry, you're all going to die no matter whether you have a will or trust. But I think you were talking about death taxes. Anyway, my bad attempt at a joke. Yes, when you have a trust, you still have estate taxes. Trusts are really put together to avoid probate and also to lessen the taxes. And so that's why we were talking about AB trust, where it's like you can really reduce the federal estate tax. But yes, the federal estate tax, it's still there. It is still present even when you do a trust. It's just you can protect yourself more from it when you do it properly, when you have good planning. So great question. All right. Any others, Stacy?
I think that's it.
Wonderful.
Okay. Well, thank you so much for coming, everyone. We're going to go ahead and wrap up this webinar at this time. We hope this information has been valuable for you. And again, if you would like to claim one of those 10 spots that are available for a consultation in the next 2 weeks, please do give us a call or email us, and our staff will be happy to assist you. Thank you again so much for joining us. It has been a pleasure. Everyone, stay safe, stay healthy, and let us know if we can help in any way.
Thanks.
Bye-bye.